Drafting an effective, persuasive, and well-pleaded complaint is one of the most important steps in the litigation process. This presentation will provide you with essential tips to ensure that in any legal context, your complaint complies with the relevant federal, state, and local rules, is well written, concise, and easily readable, alleges facts sufficient to support your claims and requests for damages, properly pleads meritorious causes of action that will survive a motion to dismiss, and requests appropriate types of damages depending on the claims that you are asserting. The first section sets forth a summary or checklist of tips that you should follow when drafting a complaint, and the second explains each item in more detail. Our goal here is to provide you with the practical tools to draft a complaint that effectively sets forth, with conciseness and precision, the facts and law that entitle you to damages or other relief. Now we'll go over the complaint checklist. When drafting a complaint, make sure that you adhere to the following. First, check the federal, state, and local rules for specific requirements regarding the filing of a complaint. Second, based on the facts of your case, perform legal research to identify the claims that you can legitimately plead and damages you can seek. Third, at the beginning of the complaint, make sure that you properly allege subject matter jurisdiction, personal jurisdiction, and venue, and cite to relevant statutes and cases that support these allegations. Fourth, draft a concise and plain statement of the factual allegations. Fifth, draft separate counts for each legal claim. Sixth, where required, plead the facts with particularity. Seventh, offer expert support for your claims if the rules require you to do so. And eighth, be sure to specifically request the relief you are seeking and a jury trial if you would like one. Drafting a complaint is not a license to hurl insults at your adversary, use over-the-top language or fancy words, or include irrelevant facts. Rather, the purpose of a complaint is to set forth, in a concise, straightforward, and logical manner, the relevant facts that support particular legal claims and that entitle you to specific relief, such as damages or an injunction. Broadly speaking, a complaint typically contains the following sections, and attorneys use headings and numbered paragraphs to delineate each section. A caption identifies the plaintiff and defendant and the court in which the complaint is being filed. There must also be a brief description of the parties, allegations demonstrating that the court has subject matter jurisdiction, personal jurisdiction, and venue to adjudicate the claims in the complaint. A concise yet thorough statement of the factual allegations that form the basis of the complaint, the specific legal claims or causes of action that allegedly entitle a person to a legal remedy. And finally, a specific request for damages or other relief, such as compensatory damages, punitive damages, or an injunction. If you are filing in federal or state court, make sure that you review the relevant court rules to ensure that your complaint complies with all requirements. Furthermore, be sure to comply with the local rules of a particular court. For example, if you are filing a complaint in the Northern District of California, you should be aware that there are 4 divisions within the Northern District and that each division may have specific local rules that you are required to follow. A judge in the San Francisco division may require, for example, that your complaint be drafted in Times New Roman font using 14-point type. If you are unaware of this rule and file a complaint in Courier New font and 12-point type, your complaint may be rejected. Thus, be sure to follow all relevant rules, particularly the local rules, to avoid this problem. Make sure to research the relevant law before filing a complaint, and make sure that you conduct research to determine the specific court that will have subject matter jurisdiction, personal jurisdiction, and venue over the complaint. Importantly, most, if not all, legal claims require a claimant to prove specific elements necessary to sustain a cause of action. For example, if you are alleging that a defendant committed negligence, you must show that the defendant owed a duty to your client, breached that duty, and directly and proximately caused harm to your client. In addition, you must be aware of potential defenses that your adversary may raise and assess whether those defenses will likely be successful. Finally, even if your claims are meritorious, they will not be heard if you file them in a court that does not have jurisdiction to hear the matter. For example, if you are alleging the defendant was negligent, which is a state law claim, you cannot file your complaint in a federal court. Furthermore, you cannot require any individual to defend against claims in a court unless the defendant has minimum contacts with the state in which the action is filed. Thus, be sure to conduct research concerning both jurisdiction and the substantive law. Otherwise, your adversary may file a motion to dismiss, and your case could be dismissed before ever going to trial. This is a recipe for malpractice. Regardless of how meritorious your claims may be, they will not succeed unless they are filed in the proper court. Thus, at the beginning of your complaint, you must set forth facts establishing that the court has subject matter jurisdiction, personal jurisdiction, and venue to hear the complaint. For example, a federal court has jurisdiction over a complaint if either the claims are between citizens of different states and involve damages in excess of $75,000, or the complaint alleges claims arising under federal laws or the United States Constitution. In addition, a court in a particular state only has jurisdiction over a defendant if the defendant has minimum contacts with the state to justify requiring the defendant to defend against the complaint in that jurisdiction. Finally, venue is generally proper in situations where the plaintiff or defendant resides in the state in which the court is located, or the acts giving rise to the alleged harm occurred there. Like we mentioned before, do not include over-the-top language, fancy words, Latin, or irrelevant facts in your complaint, and never attack your adversary. So, don't use words like indisputably, clearly, and unmistakably. Furthermore, always use the simplest word available to convey your point. For example, instead of exacerbate, choose the word worsen. Instead of the word loquacious, use the word talkative. Similarly, never use words like infra, supra, inter alia, or ipso facto. Finally, only include relevant facts, which are those that are necessary to support your legal claims, and never use language that can be construed as an attack on your adversary. In short, the complaint is not a forum in which to show off your literary skills or penchant for drama. Compare these examples. The defendant's statements were false and defamatory. The second example conveys the writer's point in clear and concise language, while the first contains over-the-top language, fancy and unnecessary words, and Latin, all of which add nothing to the statement. Thus, be sure to write in a simple and concise manner. When you do, it earns you credibility with the court and enhances the persuasiveness of your document. Ultimately, your goal is to set forth a concise, straightforward, and logical statement of the relevant facts that, if taken as true, establish each element of your legal claims. For example, if you are alleging that the defendant was negligent, you must set forth facts demonstrating that the defendant had a legal duty, that the defendant breached that duty, and that the defendant's acts or omissions directly and approximately caused your client's damages. Put simply, your facts must be connected to and establish the meritoriousness of each element of the legal claims contained in your complaint. In doing so, be sure to avoid irrelevant, unnecessary, and extraneous facts as they distract from the relevant facts and ultimately the substance of your claims. Here is an example of factual allegations that are concise, straightforward, and logical. The defendant owns and operates Walmart, located at 1000 Smith Drive in Indianapolis, Indiana. On December 1st, 2016, a severe snowstorm struck Indianapolis and resulted in an accumulation of approximately 14 inches. In the 3 days following the blizzard, the defendant failed to remove any of the snow and ice that had accumulated throughout the parking lot, despite repeated requests by pedestrians that the snow made operating a vehicle in the parking lot very hazardous. On the third day following the blizzard, the plaintiff drove into the parking lot and, as she was exiting the vehicle, sustained a serious fall that resulted in a concussion and broken shoulder. In this example, each fact that the writer alleges is directly related to an element of negligence. No unnecessary or extraneous facts are included, and the allegations are clear and easily readable. If you allege more than one cause of action in your complaint, be sure to draft separate counts for each legal claim, in which you incorporate by reference all of your previous factual allegations. In other words, under the heading Causes of Action or Legal Claims, you should have one subheading for negligence, in which you set forth the facts supporting each element of negligence, and one heading for breach of contract in which you do the same. Doing so results in effective organization and enables the reader to clearly identify the facts upon which you are relying to support each claim. In some instances, the relevant rules or case law require you to plead facts with particularity. Essentially, this means that for some claims, such as fraud, you must set forth additional and specific facts that support the asserted legal claims. Be sure to check the relevant rules and case law in your jurisdiction to identify those claims that must be pled with particularity. For some complaints, the relevant court rules or case law may require you to attach an affidavit from an expert attesting to the merit of your claim. This is most common in cases where a claimant alleges medical malpractice. Thus, before filing a complaint, ensure that your complaint contains the necessary affidavit from a recognized expert. In addition to setting forth subject matter jurisdiction, personal jurisdiction, and venue, along with the relevant facts and legal claims, you must also specify the relief you are seeking. Depending on the facts and legal claims, you may seek compensatory damages, punitive damages, or treble damages, or finally, you can even seek injunctive relief. The type of relief you seek will often depend on the injuries your client suffered, the egregiousness of the defendant's conduct, and the damages that are authorized by relevant statutes. In particular, if you request punitive damages, you will be required to plead facts specifically demonstrating that the defendant acted with a culpable state of mind. If you adhere to these tips, you will ensure that your complaint is drafted in a concise, simple, and easily readable manner that sets forth the required components to survive a motion to dismiss. After viewing this presentation, you should review complaints filed in federal and state courts and practice drafting complaints that apply the techniques we described today.